May it please your lordships.
Yes, Mr. Connolly.
I appear with Mr. Coates for the appellants Ryanair. Mr. DeHaan, QC, Mr. Coley appear for the respondent, the Civil Aviation Authority.
Yes.
My lords, by way of housekeeping, mercifully few papers. You should have one core bundle, one supplementary bundle, and one authorities.
Yes. Well, I can tell you that we have read the skeleton arguments, we've read the judge's judgment, we have read Valentin, Herman, and Cruiseman, and we think those are the key cases.
I'm grateful. That's a very helpful indication. My lords, I will, if I may, briefly summarise our appeal. Then I will highlight again briefly the uncontested evidence.
The
uncontested evidence, the unchallenged evidence, briefly, before taking you through the authorities and my submissions. My lords, the sole issue before you is the interpretation of Article 5.3 of Regulation 261/2004. We are not pursuing our fourth ground of appeal in relation to the terms of the judge's order. So the only question before your lordships is whether the strikes in this case were an extraordinary circumstance such that Ryanair is relieved of the obligation to pay compensation to affected passengers. And in answering that question, as the court has seen from the Valentin Herman judgment, the CJU directs a two-part test. Were the strikes inherent in the normal exercise of Ryanair's activities, and were the strikes within Ryanair's actual control? And by way of introduction, our points on the first and most important limb, we have four reasons why we say the strikes were not inherent in the normal exercise of Ryanair's activities. First, as you've seen from our skeleton, they had their origin in the demands of an external and independent trade union. Second,
just to unpack that a little bit.
Sorry, I mean, the first point is that they had their origin.
Yeah.
The strikes had their origin in the demands of what we say is an external and independent trade union. Of
which Ryanair staff were members.
Indeed. And I have to address that as I go through the authorities and submissions. And I see what the judge says about that. But you have our submission that the case law directs you to ask, what is the origin of the strike? And one of our points is that it has its origin in an external factor.
Right.
It's not determinative, but that's a powerful factor and favoured by extraordinary circumstances. The second point, which applies regardless of whether the factor is treated as external or not, is that the strikes were not a response to any particular action by the airline, such as a restructuring. So we are not within, we say, the Cruiseman judgment. The third point, adopting the approach of the Court of Appeal in Lipton, so we apply the ordinary meaning of the words extraordinary circumstances, and we say a strike, these strikes were extraordinary. They weren't like staff absence because of illness or a regular technical problem. The very object of the strikes was to disrupt normal activities of the airline.
So do you say these strikes were extraordinary, or do you say all strikes are extraordinary?
These strikes were extraordinary. Some strikes may not be extraordinary, as you know from Cruiseman.
But all strikes would have as at least one of their objects disrupting the airline.
Yes, my lord, but that's a factor. None of these factors I'm outlining are determinative.
Right.
Collectively, they demonstrate that these strikes were extraordinary circumstances. And my final point on inherency is, and I shall hope to show you when I take you through the authorities, that these strikes are analogous to manufacturing defects or bird strikes, or the CJU authorities on one-off external events. Because not only were the strikes driven by an external origin, but they were also extremely infrequent. Ryanair had never had a strike before these strikes in 2018. So they're not analogous to ordinary technical problems or the wear and tear of aircraft. as we saw in relation to staff illness in the Lipton judgment.
Well, so would extraordinary circumstances depend on the frequency with which a particular airline's personnel went on strike?
It could do. Frequency is not one of the most important factors, but as we see in the case law, it can be a relevant indicator of whether something's extraordinary or not. Then I take, by way of introduction, the second limb, and whether the strikes were within Ryanair's actual control, with 2 points to make there. As a matter of principle, Ryanair cannot control the demands or actions of an independent union. And on the evidence before the court, even on a limited factual inquiry, Ryanair could not have averted these strikes. So the case is not like Cruiseman, where the airline both prompted the strike by its own action and then was able swiftly to resolve the industrial dispute. My final point before turning to the unchallenged evidence is the question of the degree of factual inquiry. This is a point that was taken up by the learned judge below. And we will see from the case law of the Court of Justice that some factual inquiry is necessary, in particular where the situation falls within the list of prima facie extraordinary circumstances in recital 14 to the regulation. On our interpretation of Article 5.3, a very granular factual investigation will not be necessary. In strikes cases, the court only has to ask itself a limited number of factual questions, which do not require intensive investigation. And I suggest first, what was the origin of the strike? Was it the demand of the union? Or was the origin instead a response to some new internal measure within the airline, such as a reorganisation or restructuring?
You're obviously going to come back to all these points.
Of course, my lord. This is a very brief introduction. Yes. I'll develop them as I go through the authorities, and I'll make my submissions as I go through the authorities. And second, could the airline have taken steps to avert the strike? Did the airline resolve it promptly? And that, again, may involve some limited factual scrutiny. And that's exactly the kind of inquiry that the Court of Justice undertook in Cruiseman. And so we say it's possible and appropriate for a county court judge applying Article 5.3 to do the same, and no more. So that, my lords, is my headline introduction. Yes. I'll turn then to the uncontested evidence. The strikes with which these proceedings are concerned occurred between July and September 2018 in Ireland and various other EU member states. And as you've seen from the judgment, the key background fact was that the unions which called these strikes were all new to Ryanair. Before the strikes, Ryanair had not recognised trade unions, but had negotiated with what were called employee representative committees as permitted under local employment law. But in December 2017, Ryanair decided to deal with the trade unions and sought to enter into recognition agreements with them. And the strikes arose from the demands that the unions made in the course of negotiating those recognition agreements. And Ryanair's unchallenged evidence is that the unions took the opportunity to try to force Ryanair to change its entire business model in a way that would have stopped it operating as a low-cost airline with multiple bases. And I'll come back to where the judge records that in his judgment. As regards the reason why that is because in the Irish strikes in 2018, the union insisted that Ryanair determine promotion and rostering on the basis of seniority alone. Now, this is all in Mr. Hughes's unchallenged evidence, but I'll paraphrase, if I may, for the court. Now, determining promotions and rostering is a common feature in legacy airlines, which operate from a single hub like Heathrow. But it was completely incompatible with Ryanair's business model for two reasons. First was that Ryanair depends on having a large number of bases spread all over Europe, including many remote locations. And this avoids the high costs of operating from a single hub like Heathrow. And the second point that follows from the first is that Ryanair's flight crew leave from and return to same home base every day. And this is efficient because it means that the airline doesn't have to fly staff around to make up crew for an aircraft, and also doesn't have to pay for hotel costs and subsistence costs where staff find themselves away from their home. But that model depends on staff being willing to live in these far-flung locations, maybe very far from their homes or where their countries of their origin. And Ryanair uses promotion as an incentive to encourage staff to move to these remote bases. So a flight officer can be promoted to captain more quickly by moving from a popular location to a less popular or new base. And that's critical to ensuring that Ryanair's bases are fully staffed. And similarly, rostering for Ryanair is simply a matter of flying from and to the home base. There's no question that a staff member based in Warsaw could choose to fly from the UK to France on a particular day, which is a legacy airline issue, a legacy airline and traditional airline issue. For Ryanair, that doesn't arise. And this model, which is innovative, or was when it was created, it does generate savings which are passed through, we say, to consumers in the form of lower prices. And one can see immediately how it works. For example, in Ryanair, a young British flight officer who's prepared to make the sacrifice to move to Portugal, for example, for a few years, will achieve the rank of captain more quickly than someone who chooses to remain. In BA or in Lufthansa, that flight officer will have to wait his turn based on seniority, regardless of his talent or ambition. The other reason why legacy airlines can use seniority is because most of their staff live near the hub. And so it doesn't have this multiple base issue that is critical for airlines like Ryanair. So if Ryanair was forced to operate a seniority system, it would have to close numerous bases. Its cost would increase and its competitive power would be significantly diminished. And the judge, if I may turn briefly to the judgment, the learned judge accepted this. You see it in his judgment in the core bundle behind tab 6, paragraphs 3 and 4. Page 51 behind tab 6.
51?
51, page 51, tab 6.
You said paragraphs 5 and 6.
Forgive me, my lord. 3 to 4 on
3
page
and 4.
51.
Yes.
And in any event, this is relevant to the question of control, even if Ryanair had been prepared to change its entire business model and exceed these deadlines, it would have been impossible to make those kinds of structural changes in time to avert the strike within the time made available by the union. Because the union's demands were made in May 2018, and the strike was called for July 2018. And you see that again in the unchallenged evidence of Mr. Hughes, and I'll take you to that briefly if I may. That's in the supplemental bundle, tab 5. page 73. And you see that between paragraphs 47 to 49 on page 73. (47 to 49).
Yes.
Well, if you just keep Mr. Hughes' statement open, I'm turning now to the strikes in the other jurisdictions. I've been discussing so far the strikes that were called by the Irish Union. In the other jurisdictions, the unchallenged evidence is that certain unions insisted that the terms and conditions for third-party agency workers be changed, which was impossible for Ryanair to achieve. We had no power to dictate such changes in respect of workers who are not Ryanair's employees. And you see that in Mr. Hughes' evidence. If you go back to page 69, paragraphs 30 and 30 in particular.
Sorry, 30.
Paragraph 30 on page 69. The point is that it simply was not within Ryanair's gift to change the terms and conditions of employment for workers who are not employed by Ryanair. And if you just keep Mr. Hughes open, the important point we take from this evidence when we come to look at Cruiseman is that in no case was a strike prompted by any specific action by Ryanair, any change that Ryanair had made to working conditions. And the CAA doesn't dispute that all of the strikes resulted from demands originating from the unions.
I'm not sure I quite understand the distinction. I mean, if a union demands increased pay from its members, there's nothing that the employer has done to provoke the strike other than not increasing pay. So there is a state of affairs which the union doesn't like and wishes to change, and the employer won't change it, won't give them a pay rise, let's suppose. So where does this response to action taken by the airline come from? I appreciate in Cruiseman that is what happened, but how is that a legal distinction?
Well, that is the question of how one reads Cruiseman. One can read Cruiseman to say that's simply a factual feature of the case and makes no difference to the legal analysis. Our submission is that that is a critical distinction, which is at the heart of the legal analysis in Cruiseman. Because Cruiseman, in common with the other authorities, directs the court to the origin of the event.
I follow, but just go back to the union wanting increased pay.
Yes.
Where would that fit in?
Well,
the employer's done nothing. It's just continued to pay the employees at a rate that was, let us suppose, agreed some time ago, and the union wants more money.
Indeed, and in that situation, the union is the origin. The union's demand is the origin of the strike that follows. So that is a powerful factor in favour of seeing that this is an external event. The origin of it comes from an external body, albeit with the support and no doubt the votes of the workers of the airline itself. But the origin of the strike comes from this third-party body. Unlike, the point, my lords, is we see Cruiseman as making a limited exception to the prima facie situation that a strike is normally an external event. Cruiseman recognises in certain situations where it's prompted by particular action by the airline, it's inherent, normally would not be inherent, but in that situation it is.
You may put two elements in there. One is the external element, the trade union.
Yes.
And the other is you hadn't done anything. And they are distinct elements.
They are, my lord, yes.
Just thinking about the second element, you hadn't done anything. and picking up my Lord's example, we now have inflation at 5% or whatever. If employees say we'd like our pay raised by 5% and Ryanair says no, not likely, and then they strike, forget about the involvement of the union, that's extraordinary. Because it's not prompted by anything you did, it's prompted by the employees asking for 5%.
That, we would say that's a powerful factor in favour of saying it's extraordinary. But you've got to weigh these factors together. And for example, we accept, and we get this from the LE and TAP airline case, the unruly passenger, that one has to examine the degree of disruption, how reasonable demand is. And one can take a high-level view in the situation described by my Lord. The county court judge might say, I don't regard that as analogous to the unruly passenger. But if the union comes in and says, we want you to put your whole business model in the bin, and you've got 2 months to do it, the judge may say, well, I think that does cross the line and is analogous to the unruly passenger. And the staff are as fundamental to the business of the airline as the passenger is. But that act moves it across the line into something external and unreasonable.
Yeah. We're going to look at the authorities in a moment, I'm sure, but just to tweak the example that my Lords have given you, just to say we have the factual sort of scenario that might arise. I mean, most companies, in fact, have an annual pay review where there is a process of review. It's quite possible that in that annual review, each side will set out their respective positions at the start. The airline says, it's all been very tough, COVID and all that, no pay increase. And the union says, cost of living's gone up, we'd like at least 5%, please. They don't agree. How does it work? I mean, what's your, how does your test work? I mean, and how does the judge have to start investigating the back and forth of negotiations to reach a value judgment on who started it? I mean, is that really the sort of test that this is envisaged by this regulation?
Well, it is the test that's envisaged and applied by the Court of Justice, as we shall see when we look at the cases. But necessarily, it's a broad brush test. And we are only asking for the county court judge to apply the same broad brush approach that the Court of Justice does in a handful of paragraphs in cases like Cruiseman. But my Lord's example, or just Snowden's example, falls directly in the same area as my Lord. But that a regular pay review, which creates a regular negotiation where tensions arise and the threat of strikes is normally made, may well move it into the area of a frequent and inherent event which is not analogous to the unruly passenger, depending on the circumstances, but it sounds less like the unruly passenger in LE and TAP, and more like something that's like staff illness, the wear and tear of the aircraft or the staff. That situation may well be there, but it's a miles away from the strikes in this case. And my Lords, to be very clear, the discussion we're having is the kind of summary argument one would have before a county court judge. It would be resolved on the basis of witness statements or not, but on the papers, if possible, and rapidly. The CAA's case,
how would the average airline customer, traveller making the compensation claim, find out or get to the bottom of this factual conundrum?
The airline in these cases, and they happen all over county courts all over the country, has to explain with evidence the nature of the cause of the cancellation. In most cases, the airline pays the compensation, but where the airline is relying on extraordinary circumstances, the burden's on the airline to produce evidence to demonstrate why the situation is extraordinary. And it really is the court that scrutinises whether the evidence comes within the spirit and letter of Article 5.3. The passenger is a passenger.
So the airline has to put in evidence giving a balanced account of the negotiations which it had with unions Or
The airline has to, the burden's on the airline, and the airline has to produce its evidence and documents, and judges applying the burden of proof and recognising that the passenger is unable to gainsay it really with any evidence of its own, applies an approach that reflects the burden of proof. And that's what happens. And that isn't a complicated procedure. Judges apply justice summarily, and it's the nature of the process. But the fact that debate can happen demonstrates that our interpretation is workable. On the CAA's case, and the learned judge below, it doesn't matter how unreasonable the union is. The union can do anything. It can make any demand. And the strike that follows triggers the compensation obligation on the part of the airline.
Can I try one other example?
Okay.
This is based on Mr. Hughes' paragraph 33. He explains that in 2017 there were demands for recognition, collective bargaining. Strike action was threatened, or in some cases actually called. So suppose that Ryanair had held out against union recognition and there had been strikes. Now plainly, as we know, union recognition would not have brought down Ryanair's business model, because you did agree to union recognition and it didn't bring down your business model. How would that have played out? Would those strikes have been extraordinary circumstances?
I'm speculating, and I'll have to take. What I'm saying now is all speculation on my part. I've got no evidence, and the airline would have a view, I am sure, and may have taken a view. In fact, taken a view in relation to those strikes that took place that are referenced in paragraph 33. And so I'll be corrected, or if instructions are necessary, I can take them. But again, it will depend on the circumstances, and I hesitate to say for sure how that would fall. I can see right away that the point that I make, that the demand would cause Ryanair's business model to go in the bin, couldn't be made. But that goes to the question of control, principally. The question of inherency. Is it inherent in the business of an airline for its passengers to strike because they insist on union recognition? Is that analogous with the unruly passenger? It may not be so clear as it is in our case. But again, a county court judge in the position of my lord will take a view, and will be capable of taking a view pretty quickly.
Yeah.
But all I'm asking, my lords, is that the discussion be had. I appreciate the airline may be at the wrong end of that analysis or examination in most cases. But what the law requires is that the examination take place, not as my friends, clients say, and the judge below, that it simply doesn't matter. Once employees strike, that's always inherent, regardless of the reasonableness of the demands or the airline's ability to do anything about them. Before I turn to the law, I'm going to turn to my So, Mr. Coates reminds me that in relation to Lord Justice Snowden's point about how is a passenger claimant supposed to engage in this discussion, we know from the Court of Justice's case law that even where there are hidden manufacturing defects, so a defect caused by the manufacturer that the airline couldn't have seen, and that is an extraordinary circumstance on the case law of the court, which means the passenger doesn't get compensation. That is an area where a county court judge, looking at the evidence, would say extraordinary circumstances, and therefore no compensation. But obviously a passenger would have no ability to engage with that discussion at all. But that's still an outcome contemplated by the case law of the court. So as it fortifies, if I may, in my submission, the point I made earlier, which is in most of these cases the passenger won't be able to engage or contradict with evidence of his own or her own. It's a question for the airline to satisfy the court that extraordinary circumstances, narrowly construed, where the burden is on it, do apply. I'll turn then, if I may, to the law, to the regulation. And that is in the authorities bundle. You behind tab 2. And the regulation begins on page 24, and we see in recital 3 a reference to its predecessor, Council Regulation 295/91, which created a basic protection for passengers. But the number of passengers denied boarding against their will remains too high, as does that affected by cancellations without prior warning. And I'll come back to that problem of cancellations without prior warning and what the new regulation sought to achieve. It sought to discourage these kinds of cancellations. And then we turn to recital 12. Over the page, trouble and inconvenience to passengers caused by cancellation of flights should be reduced. This should be achieved by inducing carriers to inform passengers of cancellations before the scheduled time of departure, in addition to offer them reasonable rerouting, so that passengers can make other arrangements. In this, air carriers should compensate passengers if they fail to do this, except when the cancellation occurs in extraordinary circumstances, which could not have been avoided even if all reasonable measures have been taken. Pausing there, my lords, no point is taken against us on reasonable measures. If we succeed on persuading the court that extraordinary circumstances apply, the CA does not say that we fail to take reasonable measures. And then critically, at recital 14, excuse me, as under the Montreal Convention, obligations on operating air carriers should be limited or excluded in cases where an event has been caused by extraordinary circumstances, which could not have been avoided even if all reasonable measures had been taken. Such circumstances may, in particular, occur in cases of political instability, meteorological conditions incompatible with the operation of the flight concerned, security risks, unexpected flight safety shortcomings, and strikes that affect the operation of an operating air carrier. So recital 14 gives you the prima facie list. The fact that something falls in that list is not determinative, and it's not an exclusive list, but we say it's a strong indicator of the interpretative approach to the substantive provisions of the regulation. And it is to those I now turn. Bless you, my lord. Page 27, Article 5. And I'll take the court, if I may, through the various provisions of Article 5, so you see the full spectrum of protection passengers receive. Because in the case of a cancellation of a flight, the passengers concerned shall be offered the following things. And first, at A, assistance by the operating air carrier in accordance with Article 8. And if my lords look across over the page, you see what Article 8 is. On page 28, the right, the heading is sufficient. A right to reimbursement or rerouting. So you get your money back or rerouted otherwise. Then back to Article 5, 1b. The passenger is also offered assistance by the operating air carrier in accordance with Article 9.1a and 9.2. When we look across the page to see what that is, Article 9 is the right to care. So where there's a cancellation, if we look below the heading, we see that passengers are entitled to free meals and refreshments, hotel accommodation, meals and refreshments, and then to communications, telephone calls, emails, and so forth. And then back to Article 5, 1c. In addition to reimbursement, rerouting, and right to care, passengers have a right to compensation by the operating air carrier in accordance with Article 7, unless they're informed of the cancellation at least 2 weeks before the scheduled time of departure. So where the airline cancels more than 2 weeks before departure, no compensation. But if you're within the 2-week window, it triggers the right to compensation. That's to stop these last-minute cancellations or discourage them. And we look then at Article 7, and you see, I'll show you very briefly, my lords, just Article 7.1, the amounts of compensation. So it's €250 for flights of 1,500 kilometres or less, a greater sum, €400 for flights between 1,500 and 3,500 kilometres, and €600 for all flights that aren't within A and B. And I'll come back to those figures because, as you'll see later, my lords, those compensation figures may be more than the price of the ticket in the case of a low-cost airline, and often are. And back to page 27, we see the exception to this right to compensation in Article 5.3. The operating air carrier shall not be obliged to pay compensation in accordance with Article 7 if it can prove the cancellation is caused by extraordinary circumstances, which could not have been avoided even if all reasonable measures had been taken. So, since my lords have seen, the regulation provides for reimbursement, rerouting and care. The compensation is extra. So, on one view, one might say the compensation is unnecessary to protect consumers. What is the purpose of that extra protection that the regulation provides? And we get a clue as to the purpose of it in the travaux préparatoires, the pre-regulation legislative materials. And we see that, forgive me, in the supplementary bundle behind tab 10. Supplementary bundle, tab 10, page 188. And I'll take, if I may, to three parts of this. So the first, that liberalisation of air transport has brought advantages to passengers, the first paragraph. If you skip down, my lords, about 4 lines down, the sentence, denied boarding and cancellation of flights for commercial reasons, provokes strong resentment, not only because they cause serious delay and upset travel plans, but also because they represent a failure by the transporter to respect its undertaking to carry passengers with reasonable dispatch. So what's a commercial reason for cancellation? It's where the aircraft is half filled, or the airline can make more money by using the aircraft for a different reason, and it decides to cancel the flight for its own commercial reasons. And if you go down to paragraph 5 on the same page, the Commission believes that the old regulation still doesn't protect passengers adequately when confronted by denied boarding or cancellation. The original and amending regulation obliges carriers to compensate and assist passengers. Over the page, they do not, however, dissuade them. This is still the old regulation. The old regulation still doesn't dissuade the airlines from excessive denial of boarding or cancellation, nor to give incentives to balance the commercial advantages against the cost of passengers. Consequently, too many passengers would have continued to suffer from these practices. So the regulation is designed to create a financial incentive to punish the airlines when they do this, to incentivize them not to do it. And if you go over the page to 190, paragraph 21, the Commission therefore proposes to keep an important feature of the 1998 proposal, as amended following the Parliament's opinion, the extension of the provisions of compensation. Next sentence, an exception would naturally be made for cancellations that an operator can prove were made for reasons outside its responsibility.
Sorry, I've just missed the paragraph.
Oh my lord, it's paragraph 21 at the bottom of page 190.
I do notice, incidentally, in paragraph 6, there's references to the trouble and waste of time that passengers suffer when they are delayed or denied boarding.
Absolutely, and that's why...
I mean, that's another issue to which the compensation is directed.
Well, if these cancellations, the vice, in my submission, my lord, is that the cancellations are commercial. The airlines have a choice. They're doing them for commercial reasons, and the passengers suffer significant disruption and inconvenience as a result. And by forcing the airlines to pay compensation when they do these cancellations, it will incentivize them not to do them, and will reduce this prejudice to passengers. And in my submission, that's made good by paragraph 21 on page 190, where the Commission says they'll extend the provisions of compensation. With the second sentence, an exception would naturally be made for cancellations that an operator can prove were made for reasons outside its responsibility, would this allow a carrier to use safety or security as a pretext for cancelling flights when it really does so on commercial grounds? In fact, there's obviously a typo. In fact, under its air operator certificate, it's required to keep records of such incidents, which are subject to inspection by the authorities.
Does that include strikes? You have to record that, do you, on your operator's certificate?
I'll check one. We can check. I'm not going to. I don't know, my lord. This allows effective control and should minimise use.
What you have to record on your air operator certificate seems to be tied to this concept of reasons outside its responsibility.
Yes, that's certainly the suggestion here. I just don't know what the rule requires for the purpose of completing that form, but I'm sure we can find out. We'll take instructions. But all I wish to take from this proposal for the regulation is its focus on preventing commercial cancellations, those which the airline has chosen to make for its own selfish commercial reasons, and to discourage it from doing so by forcing it to pay, in addition to reimbursement and rerouting and so forth, compensation. And now I would, if I may, take you to the case law. And I'll begin with Lipton, because although my Lord Justice Lewison said that Valentin Herrmann is a very important case, it is referred to in Lipton that also gives some of the updated authority. Lipton is in the authorities one and tab 17. And you can go please to page 191 and paragraph 13. Just for the heading, this is where they deal with the test. The Court of Appeal deals with the test for extraordinary circumstances. And over the page at 14, paragraph 14, Lord Justice Coulson sets out the key passages from Valentin Herrmann. And forgive me, because I know you've seen these passages already, but I'll go through them again if I may. I'm looking at the indented paragraph 23. This is the test. The only important part is the bit at the end that says that to be extraordinary, the event has to be not inherent in the normal exercise of the activity of the air carrier and is beyond the actual control of that carrier on account of its nature or origin. And obviously I've been focusing on origin in my submission so far.
That suggests that both conditions have to be fulfilled.
Yes. Indeed, exactly. Then paragraph 24, these are the facts of that particular case in Valentin Herrmann. It was engine trouble. And here the Court Justice said, in light of the specific conditions in which carriage by air takes place and the degree of technological sophistication of aircraft, it must be stated that air carriers are confronted as a matter of course in the exercise of their activity with various technical problems to which the operation of those aircraft inevitably give rise. It's in order to avoid such problems and take precautions against incidents that those aircraft are subject to regular checks which are particularly strict and which are, and I'll refer to this later, part and parcel of the standard operating conditions of air transport undertakings. And just pausing there, you see the next line, the resolution of a technical problem caused by failure to maintain an aircraft must therefore be regarded as inherent in the normal exercise of an air carrier's activity, suggesting in my submission that this is a matter for which the airline is responsible and needs to be able to prevent it or resolve it when the problem arises. But then we skip down to paragraph 26 of Valentin Herrmann, where the court says, can't be ruled out that technical problems are covered by those extraordinary circumstances to the extent they stem from events that are not inherent in the normal exercise of the activity of the air carrier and are beyond its actual control. And that would be the case in a situation where it's revealed by the manufacturer of the aircraft, comprising the fleet of the air carrier concerned, or by a competent authority, that those aircraft, although already in service, are affected by a hidden manufacturing defect which impinges on flight safety. And I rely on that as an example of something which is impossible for the airline to resolve. Now, we go, if I may, to the next paragraph of Valentin Herrmann, paragraph 36. And the court there said, it's the referring court to ascertain. So there's a factual inquiry that the Court of Justice is directing the referring court to undertake, to ascertain whether the technical problems cited by the air carrier in question in the main proceedings stem from events which are not inherent in the normal exercise of its activity and are beyond its actual control. So,
just before you leave paragraph 36, we then get the Court of Justice saying that the frequency isn't itself a factor.
Indeed, my lord, and that suggests that frequency was irrelevant. Then we see in later cases the domestic court saying actually frequency can be an indicator, not a determinative factor at all, but it is relevant. But I'm not suggesting that the rarity of something is ever sufficient in itself to demonstrate extraordinary circumstances. And then in paragraph 15 of Lipton, over the page 193, the court cites another decision of the Court of Appeal in Hussar, and you see the relationship between the two limbs of the test. You see this between, about halfway through, between B and C. The second limb will take its meaning from the first, rather than vice versa. The event causing a technical problem will be within the control of the carrier if it is part of the normal everyday activity which is being carried on, and will be beyond the carrier's control if it is not. And Lord Justice Elias recognised in the next paragraph in Hussar, in the indented passage, that can be said to render the second limb redundant, but it doesn't, in his view, strip it of all significance. It helps identify the parameters of those acts which can properly be described as inherent in the carrier's normal activities and those which cannot, and chime to the examples of events in recitals 14 and 15. It makes clear that events which are beyond the control of the carrier because of extraneous acts of third parties, such as terrorism, strikes, or air traffic control problems, or because they result from freak weather conditions, cannot be characterised as inherent in the normal activities of the carrier. So the first, what we take from this is that the first limb, inherency, is the most important, but the second limb still has a role. And if you skip down, please, my lords, to paragraph 17 of Lipton, there's a reference to, under the heading mechanical defects in the aircraft. I rely on it only for the further quote from Hussar. You see the very bottom of page 193. In Hussar, technical problem was held not to amount to extraordinary circumstances, even though it was unforeseeable and wasn't preventable by prior maintenance of visual inspection. Lord Justice Elias said that technical problems arise as a matter of course in the ordinary operation of the carrier's activity. Some may be foreseeable, some not, but they're all inherent. They're part of the wear and tear. I'm going to skip, my lords, if I may, the summaries of the EU cases that follow, because we'll need to go back to those in more detail, and go to page 197 and how the Court of Appeal answered the question in that case, which was a staff illness case, as you see. First, ordinary meaning of words, paragraph 30. The Court of Justice emphasised...
Sorry, where are you? Paragraph 30?
Paragraph 30, yes, my lord.
Ordinary
Page 197. So the expression extraordinary circumstances must be given its usual meaning in everyday language. That means something out of the ordinary. Staff illness and the need to accommodate such illness on a daily basis is commonplace for any business. It is a mundane fact of commercial life. And 31, the straightforward reading of the regulation takes account of its purpose, which is to provide a high level of protection for consumers. And Article 5.3 must be construed strictly. And then 32, that interpretation is consistent with the authorities in respect of staff absence. It's not one of the factors identified in Recital 14, if I may say so, unlike strikes, that is indicative of exceptional circumstances. The only factor there listed that is potentially referable to staff absence is strike action, which is, of course, much more likely to be out of the ordinary than a sick member of staff. And then 33, about halfway down that paragraph, referencing Cruiseman, if the CJU, if as the CJU said at 41 of Cruiseman, air carriers may, as a matter of course, when carrying their activity, face disagreements or conflicts with all or part of their members of staff, it can also be said with certainty that, again, as a matter of course, when carrying out their activity, they have to take account of the potential absence of their staff in relation to illness. And then 34.
The Finnair case was not strike by the staff employed by the airline, though.
I think that's right, my lord. I was once familiar with that case, but not anymore. Jenny will tell me if that's right.
Yeah, strike at Barcelona.
Sorry?
According
to paragraph 25.
Yeah, it says it was a strike at Barcelona Airport.
Ah, yes, you're quite right, my lord, yes. Then in 34, Court of Appeal deprecated the need for detailed analysis of causation. And I don't, I adopt that, and you've got my submission on why that can be done in cases like this. But even there, Lord Justice Coulson said, halfway down paragraph 34, the CJEU in Cruiseman was required in that case to do a certain amount of investigation because strikes are one of the indicia of extraordinary circumstances listed in recital 14.
Well, what about Lord Justice Coulson's first point in that paragraph? Doesn't accept the precise nature of the strike made any difference.
Well, yes. Well, first that's obiter, obviously, in the Lipton judgment.
Certainly.
In order to Justice Coulson doesn't explain why he's formed that view. My lords will form their own view when you see the Cruiseman judgment. When we'll come to. Paragraph 35, there's a reference to how an analogy can be drawn with wear and tear and staff. Lord Justice Coulson refers to wear and tear in Hussar, and then below D, he says, those cases strongly suggest a similar answer in this appeal. An air carrier's operation depends on two principal resources, its people and its aircraft. Wear and tear of the aircraft and its component parts is not extraordinary. The wear and tear on people, manifesting itself in occasional illness, should not be regarded as any different. Put another way, the captain is just as much part of the operating system. Over the page at 199. Mr. Shaw maintained, by reference to paragraph 36 of Voluntary Impairment that we've just seen, the court should not have regard to the frequency of the particular event. And Lord Justice Coulson says that's based on a misreading of that paragraph of the court's judgment. What the court was saying was the frequency of the technical problems experienced by an air carrier was not in itself a factor. But as a matter of common sense, frequency will sometimes be relevant to whether or not the event in question could be categorised as being out of the ordinary. And you see the rest of what Lord Justice Coulson says. And that comes back to the point I was trying to make to Lord Justice Newey earlier about how frequency can be of relevance. And then finally in Lipton, paragraphs 48 and 49 on the degree of factual scrutiny. This is on page 201. And again, Lord Justice Coulson deprecates the kind of detailed factual analysis urged by counsel for the airline in that case. But he does see, halfway down 49, there may possibly be a need for a more detailed investigation in a case where there's an issue as to whether or not the recital 14 indicia are in play, as occurred in Cruiseman, recognising that in Cruiseman there was that kind of factual investigation, not a staff illness case. And so, in other words, we move from Lipton to the CJEU authorities, and I won't take you to all of them, but in chronological order. we begin with Pescova, behind tab 10.
Tab
10.
10.
The authorities.
Yeah.
In fact, if I may, sorry, I'll begin at tab 11 with the Advocate General. The Advocate General wasn't followed by the court, but it's useful to see his opinion because it gives you an indication as to what the court accepted and did not accept. And so the Advocate General's opinion is behind tab 11. And if I could go, please, to page 131. This was the bird strike. And paragraph 27. So the Advocate General said the absence, he's referred to the test for extraordinary circumstances. And he says, the absence of one of these conditions prevents the classification of an event as extraordinary circumstance. This applies in the case of a collision between a bird and an aircraft. Although, owing to its nature or origin, such a collision is beyond the actual control of the air carrier, it cannot be regarded as not inherent in the normal exercise of the air carrier's activity. And in the paragraphs that follow, I'm just going to pick up the first sentence of each. 28 on page 132. The Learned Advocate General notes first, the wildlife hazard involved in air transport is a well-known phenomenon and perfectly well understood by the relevant actors. Then at 30, he says it's also known the likelihood of collisions with birds is greater at certain periods than at others, the most dangerous periods being migration seasons, when young birds unaccustomed to aircraft take flight, the most dangerous times being dawn and dusk. 31, collisions between one or several birds and an aircraft are therefore a common occurrence experienced by various economic actors operating in air transport. 32, pilots themselves have an important role in the management of wildlife hazards, whether before, during, or after the flight. And then 33, I'll take you through all of the paragraph. It's therefore clear that a collision between a bird and an aircraft is in no way an event which is out of the ordinary. In fact, it's quite the opposite. The frequency of such collisions and the fact that they are taken into consideration in the design of the aircraft, in the management of airports, and at the different phases of a flight sufficiently demonstrate, in my view, that such an event is very much inherent in the normal exercise of the activity of the air carrier. Any other conclusion would lead to the legal classification as extraordinary of an event which is perfectly ordinary. And over the page, 38, paragraph 38. It was argued at the hearing that an event such as a breakdown caused by the premature malfunction of an aircraft component and an event such as a collision between an aircraft and a bird were incomparable, inasmuch as the first is an endogenous cause, the second an exogenous cause. That's our internal-external distinction. That is, in plain language, according to whether the cause is internal or external to the aircraft. However, the question arises as to what legal basis would allow the court to draw from that factor alone conclusions which are so diametrically opposed and so strongly undermine consumer protection. That argument, which renders the application of a legal principle dependent on whether the risk is situated within the structure of the aircraft or outside it, in no way alters the legal nature of the event. Whether that risk is inside or outside the cabin, the only relevant feature in the light of the case law of the court is whether or not it's inherent in the normal exercise of the activity of the air carrier, which the Advocate General said he demonstrated. So far, very clear. But that analysis was not followed by the Court of Justice in Pescova. And you see that from the judgment after tab 10. And there the court took a different approach. Go to paragraph 22 on page 120. The Court of Justice said, paragraph 22, the court has deduced therefrom that events may be classified as extraordinary circumstances within the meaning of 5.3 if, by their nature or origin, they are not inherent in the normal exercise of the activity of the carrier. 23, and this is dealing with inherency now, it's clear from the court's case law that the premature failure of certain parts of an aircraft does not constitute extraordinary circumstances, since such a breakdown remains intrinsically linked to the operating system of the aircraft. And in my submission, what they are saying is that it's internal and the airline is responsible for such problems. In the next sentence, the court's dealing with control. That unexpected event is not outside the actual control of the air carrier, since it is required to ensure the maintenance and proper functioning of the aircraft it operates for the purposes of its business. However, now we see the different approach in 24, paragraph 24. In the present case, collision between the aircraft and a bird, as well as any damage caused by the collision, since they are not intrinsically linked to the operating system of the aircraft, are not, by their nature or origin, inherent in the normal exercise of the activity of the air carrier, and are outside its actual control. And therefore, the collision is classified as extraordinary circumstances. Now, my lords, it's clear as a matter of fact that airstrikes are part and parcel of the activity of the airline. So why are they excluded? And the answer in our submission is that they are, as the court says, external. The court's adopting the external-internal approach that the Advocate General rejected. And we see that from the cases that follow, that if the source of the disruption is internal, it is likely to be inherent.
But external to what?
External to the airline, the aircraft, external to the normal operation of the airline. And again, I'm not suggesting these are bright line distinctions, but if it's internal, the source of the disruption is internal, it's more likely to be inherent. And if the source is external to the airline, it's more likely not to be inherent. And that ties in with the point I was trying to make to my lords this morning about labour relations. In some situations, an airline will have control. It will be within its gift. And the degree of the dispute may arise from a labour relations discussion that is more inherent, such as the regular wage discussion that Rory mentioned to me. But in other situations, the airline will have zero control, and the event will be genuinely disruptive. And in those situations, we say it moves outside the internal world and into something which is extraneous. Therefore, the airline cannot possibly be responsible for it in any legal sense.
Well, I can see that some strikes may fall into that category. If there's a strike called in protest against some government policy, for instance, which has got nothing to do with the airline, I can see that might well fall outside. But this strike is all about what goes on within the airline, how it promotes its staff, what its rostering arrangements are, and so on.
My Lord, yes. And that's the point that was found against me by the judge below.
Yeah.
But again, you look at a sense of inherency in control. Inherency, a strike like that is not part of the normal. The strike where the union is asking the airline to change its whole business model is not a normal event. It's not part of the normal activity of the air carrier. And it's not inherent. It's coming from something which is external. And I say that because, and I do rely on the fact that when the ERCs were negotiating with Ryanair, this never arose. The unions that when
well, is that right? Because we saw from paragraph 33 of Mr. Hughes that while you had not yet recognised any unions, there were threats of strikes and strikes in relation to recognition.
Unfortunately, my Lord, there is evidence about that, and there was nothing. There were rumblings, but nothing like the disruption that followed.
There may have been nothing like the disruption, but there were strikes, in fact.
There were, but much more limited. So perhaps with the ERCs, no strike arose from any dispute with any ERC. I think that's fair. The strikes that were discussed before arose in a different context. But when the unions were involved, and I mean no criticism at all, it's simply a fact that the union saw it as an opportunity to change the Ryanair business model to a model that they believed was better and that all airlines should follow. But it was a totally different model. It was impossible for Ryanair to achieve it. And the unions said, now is our chance to fight this battle, and we'll fight it. And it was as extraneous as one can have, fall short of a sympathy strike or a strike for political reasons.
can I just try to break it down a moment? It is inherent in the activity of the airline that it carries on negotiations with employees or their representatives, presumably.
Yes.
And it's also inherent in that sort of activity that employees or their representatives will threaten strike action on occasion.
Yes.
Also inherent that they will take strike action on occasion.
That will depend. It must follow from the first that there will be that may well be inherent in particular circumstances. Yes.
So it either comes down in this case to the involvement of the union, but that seems strange. One would think that if it's inherent that you can have threats of strike action or strike action by employees, the fact that you've got the union as their representative can't make a difference.
Well, our submission is that it does, because it is a third-party independent body with its own, and entitled to have its own separate agenda, its own political view. Again, no criticism, but it is definitely a separate independent body. It may be endorsed by the workers, but it does introduce a separate and independent element over which the airline really has no control at all. That's its very nature.
So if the workers themselves, the pilots themselves, never mind the union, had made the same demand of Ryanair, one of your elements would be missing.
One of the elements would be missing, yes. One of them, yes. We'd be closer to the cruiseman situation, but not all the way, because of the important distinction with the cruiseman.
I mean, if it isn't the involvement of the union, then what must make this different from what we were just postulating would be the impossibility of Ryanair meeting the demands.
That's the so if it's not the union, the first distinction is the fact that it's not caused by any particular action that Ryanair takes. Because I'm still maintaining my submission that cruiseman shows a limited exception where a strike, notwithstanding recital 14, will not be extraordinary if it is prompted by a particular action by an airline. So even if it's just the workers, even if my point about the union is bad, there's still no suggestion here. In fact, the finding by the judge is that the strikes were caused by, originated from, a very clear unilateral demand from the union. And then the next point is the point made to me by my Lord Newey, that it was impossible to comply with it. And that, again, is a finding of fact. So that just for my Lord's note, the fact that there was no strike while the ERCs were the means by which the workers, or the employees dealt with Ryanair, that's in Mr. Hughes' evidence of paragraph 32. And the Finnair point, yes, my Lord, it was not the airline's staff that were striking. All we get is
not that I suspect it matters, but how do you reconcile what you said about paragraph 32 with what is said in paragraph 33? I mean, unions had not yet been recognised at the point at which the strikes were held.
Sorry, no, you're talking about
Yes, sorry. You say
Mr. Hughes' evidence.
You say there had been no strikes when you had the ERCs.
Yeah, my Lord, it's unclear.
You must still have had ERCs when the strikes were held in paragraph 33, presumably.
I'll have to give you an accurate account of that. I'll be given a note. Somebody will explain it to me.
Yes.
So in order to explain why Mr. Hughes' evidence is accurate in paragraph 32. But what's clear, I suppose, make this point, and you'll see it in Pescova and in Cruiseman and in other cases, is that if the construction of Article 5.3 that we see in the judgment below is correct, it begs the obvious question: why did the court not say it? In Cruiseman in particular, why is the court drawing these distinctions? And we go, and then if we go to Cruiseman now, hopefully I can make that good. So if you you could turn to Cruiseman, please, in tab 12 of the authorities. This is what I would say the key pre-Brexit authority, although I rely heavily on the LE case also. So the facts are very important in Cruiseman, especially when you look at control. And we see that from page 140. Page 140, paragraph 7 following. So it's apparent from the orders for reference that the flights that were cancelled were subject to a delay equal to in excess of 3 hours upon arrival due to an exceptionally high number of absences on grounds of illness. Following the notification on the 30th of September by that air carrier's management to its staff of company restructuring plans. So the company announces the restructuring plans on the 30th of September. Then in paragraph 8 we see that usually the rate of staff absenteeism due to illness is about 10%. Between the 1st of October and the 10th of October, it went up between 34% to 89%. So the announcements on the 30th of September, the amount of staff absenteeism due to illness increases very significantly a couple of days later and for the rest of the week. Accordingly, from the 3rd of October, we see at paragraph 9, the airline abandoned its schedule. And then at paragraph 11, on the evening of the 7th of October, the management of Newey informed its staff an agreement had been reached. So the airline reaches agreement on the 7th. The announcements on the 30th, staff walk out on the 1st, agreements reached on the 7th. So it was an issue which was capable of being cured very quickly. And that is, as I say, relevant to the issue of control. Then we turn to the reasoning of the court, and that's at page 146 in paragraph 38. And because I rely so heavily on this, forgive me if I take it quite carefully. The first sentence in paragraph 38. In the present case,
Sorry, page
145, my lord. Page 145.
Yes.
Paragraph 38.
Right.
So in the present case, as apparent from the file submitted to the court, that the wildcat strike among the staff of the air carrier concerned has its origins in the carrier's surprise announcement of a corporate restructuring process. So, pausing there, one sees right away the court asking what is the origin of the strike, and it's the carrier's surprise restructuring. That's also a factual investigation that had to be undertaken. Then, next sentence. That announcement led, for a period of approximately 1 week, to a particularly high rate of flight staff absenteeism. Pausing there. That again is a finding of causation. It's the announcement that led to the staff walkout. As a result of a call relayed not by staff representatives of the undertaking, but spontaneously by the workers themselves, who placed themselves on sick leave. And the court there saw it relevant to note the strike was not called by a union, some third-party representative, but was spontaneous, a walkout by the workers themselves. Paragraph 40, as correctly noted by the European Commission, the restructuring and reorganisation of undertakings are part of the normal management of those entities. 41, again, it's emphasised that conflicts or disagreements arising from that, when carrying out their activity, will face those disagreements with members of staff. And that ties into the point made to me by my lords that, well, in old situations, airlines have disagreements with staff members which can lead to threats of strike action. And if the court stopped there, I might have some difficulty with this judgment, but it doesn't. Paragraph 42 is an important limitation. Therefore, under the conditions referred to in paragraphs 38 and 39 of this judgment, the risks arising from the social consequences that go with such measures must be regarded as inherent in the normal exercise of the activity of the air carrier concerned. So we look back to see what are these conditions on which the finding is based, and that is 38. It's the finding that the strike had its origins in the surprise announcement of the corporate restructuring. And at 39, the same causal finding that it was the announcement of the restructuring that caused the wildcat strike. That is the basis for the finding in paragraph 42.
Can I just ask you, in 40 it says, restructuring and reorganisation of undertakings are part of the normal management of the entities. I mean, we don't actually get any information as to what the restructuring announcement was. I mean, it's possible to think that it might have been something to do with financial restructuring, i.e. putting a proposal to creditors, but it's equally possible that it's simply saying we'll have to make economies, we'll have to change the numbers of staff, where the staff are deployed and the like. I mean, why isn't the decision by Ryanair as to where to deploy its staff and how to deploy them and how to reward them, how to incentivise them, that's all part and parcel of normal activities, isn't it? So that any suggested change to it that might be suggested, whether by a union or anybody else, is just part and parcel of Ryanair's business, isn't it?
My lord, I can obviously that's the point I've been dealing with in this case for a long time. But the point is that the Court of Justice, if their view had been that it doesn't matter who causes the strike, what matters is that it arises from disagreements, which arise as a matter of course, that would be the end of the judgment. But the crucial is the court is anxious to base its judgment on the question of the origin of the strike. And the origin here is the particular act of the airline, the surprise announcement, which again is a contrast, if I may say so, a relevant contrast with the regular pay negotiation discussion that my lord raised with me earlier. The court plainly thinks it's relevant that the origin of the strike in Cruiseman was this surprise restructuring announcement, which was announced to staff members and which plainly caused them to walk out the following day. And that's central to the conclusion the court reaches, which is why they, in my view, in my submission, forgive me, they are seeking to give a limited application of Article 5.3 to internal strikes by employees.
But they do say, without qualification, that restructuring and reorganisation of undertakings is part of the normal management. And they also say, without qualification, that air carriers may, as a matter of course, when carrying out this, face disagreements or conflicts with all some of their staff.
My lord, yes. And
that those two statements are unqualified.
They are. And that's why I said to my lord that if the court stopped there, I may be having to make a different submission, but they don't, and 42 is important. My lords may say that clause in 42 doesn't matter. The nature of, as my lords are very familiar with, the Court of Justice expresses itself in extremely terse reasoning. One cries out for more analysis, one never gets it. This is relatively expansive reasoning by the standards of the court. I have to work with what I have, but my submission is the words are chosen very carefully.
But surely in 41, when they say the risks arising from the social consequences that go with such measures, surely they're talking about the risks of disagreements or conflicts with part of the staff because of the social consequences of reorganising the undertaking. I mean, the such measures are plainly restructuring and reorganisation of undertakings referred to in paragraph 40. And the risks arising from the social consequences are that the pilots or the staff don't like what's being proposed by, don't want to change.
Indeed.
Or want something else.
But my submission is that that has to be read. That reference to social consequences that go with such measures has to be read consistently with paragraphs 38 and 39. And what the court, in my submission, is saying is that if you're going to make a sudden surprise announcement of a restructuring, which I infer is something major because it calls this walkout, immediate, spontaneous walkout by workers. If you're going to do that, notwithstanding the fact that restructuring reorganisation is part and parcel of your work, you have to deal with the consequences. And it's the social consequences that go with announcing restructuring in that way, that means that even though this is strictly speaking outside the control of the airline, it is in reality within their control, and it's not extraordinary. In Cruiseman, my lords, if the court in Cruiseman approached Article 5.3 in the same way as the judge below, this judgment would be written very differently. And it's written in this way for a reason. The words are carefully chosen, and it is a limited finding. And the reference back to 39 and 38 is important.
Yeah, so that really depends on under the conditions referred to in paragraphs 38 and 39.
Yes. And then paragraph 44. And then
we get some help from that too. That they say that's a relevant fact, that it all stemmed from the decision taken by the carrier.
Absolutely, Martin, because we've been discussing inherency, but now we're on control. On control, Cruiseman is very clear, we say. The fact that it could be wrapped up by the airline so quickly is plainly relevant to the question of whether the airline had control over the situation or not.
I mean, you could possibly spin that differently. The point might merely have been the fact that the airline was able to conclude an agreement that resolved the dispute was significant. And if that were how it were correctly to be seen, well, you concluded an agreement. I mean, you were able ultimately to reach an agreement with the unions.
Ryanair or the... Ryanair, yes. Yes, but not, well, eventually, but not I mean, it's true. One could say that the fact that, and this is what the judge says, the fact that agreement is ultimately going to be reached in every case shows that you have that degree of control. Now, of course, it's not strictly true. If the demand leads to the insolvency of an airline, the airline may be unable to agree or face insolvency. But in my submission, control within the meaning of the case law cannot be inferred simply by virtue of the fact that eventually an agreement is reached. It does involve asking whether, and the word actual is important, whether the airline does have some form of actual control. Simply giving in at the very end and acceding to all the demands doesn't indicate control in the meaning of these cases. Here in Cruiseman, it's important because the agreement was reached so quickly. The airline introduced something and then reached agreement within a week. And that's, and if I may say so to my lord, that's the more straightforward interpretation when one looks at control. Paragraph 46, if I'm
just hold on a moment. So on day one, the pilots go on strike. On day two, a flight is cancelled and the passenger asks for compensation. Does the passenger have to wait to see whether the airline and the pilots can resolve their differences? And if so, why?
Well, again, practically speaking, I mean, there's no bar on the passenger seeking his or her compensation at that point. It doesn't cost anything to seek the compensation.
Right. And what does the airline say? We're still talking to the pilots. Hang on a minute. We'll tell you later on whether this is extraordinary or not. That seems counterintuitive.
Well, my lord, not necessarily, because if it's the next day, it's perfectly normal for the airline to say, because the airline has to take its own view first whether it's extraordinary. And by day two, the airline will not be able to take a settled view. It may require a week or so, or maybe more time. And certainly by the time it comes to be resolved by the small claims court or the county court judge or whoever else in any member state is dealing with it will be clear by then whether it's extraordinary or not. But it's not counterintuitive for the airline to say to the passenger on day 2 or even day 7, we're going to delay processing your claim until we can take a view whether this is genuinely extraordinary or not, because it may depend on the position the union took. And so it may require a week or two, but that's not contrary to the scheme.
I mean, that's a very different quality from a nail on the runway or a bird strike or something which happens. You know when it happens. You may have to find out later on why it happened, but you know it's happened on that day. You know that the flight has been diverted because of a passenger getting drunk on board. You know that there's been an act of sabotage. You know that there's been an event which has caused the flight to be cancelled. Whereas with this kind of rolling situation, you might have to wait some time before you know.
But my lord, in all of those cases that you've mentioned, they all call for the same kind of factual examination, which may take a matter of weeks or even longer. The court, as we'll see in the LE and
well, it's not so much the factual investigation, it's not the investigatory part. You've got to, on this example, of your strike example, you would have to wait to see how the facts unfolded after the cancelled flight.
My lord, yes.
Which would not be the case for any of the other circumstances which amount to extraordinary circumstances. I mean, if there is a strike by staff at Barcelona Airport, you
yes.
can say on the day the flight was cancelled, it's got nothing to do with the airline. You know that straight away.
Yes, and that's an easy example because you know straight away. But the other examples, my lord, do will not be clear after a week or two. The example of the screw on the runway or the petrol on the runway that we have in the Moen's case, the court said that's only extraordinary if that petrol doesn't come from your aircraft. So it does require an examination of whether the petrol upon which the airline.
Oh yes, you need to examine the facts at the date of the cancellation, not the facts 2 weeks later when you ask yourself, has the airline now settled its differences with the staff?
Yes, but from the regulation is to be construed from the passenger's perspective. From the passenger's perspective, it doesn't matter if it's clear that extraordinary circumstances arise on day 2 or day 7, the fact that some time needs to pass for it to be resolved. From the passenger's perspective, the delay that involves is the same as the delay that arises from asking whether the petrol came from the airline that had to cancel, or in LE, as we'll see, a disruptive passenger is treated as extraordinary circumstances unless it's shown that the airline contributed to his disruption, so by giving him too much alcohol, for example.
I suppose the point is that this exemption in Article 3.5 only applies to the obligation to pay compensation. So you've got no such exemption for the obligations to care for the passengers and provide them with rerouting, etc., etc., etc.
Precisely.
So it's only a question of payment of compensation that we're debating here.
It's not as urgent for the passenger. What's urgent for the passenger is reimbursement, rerouting, and care.
Yep.
Having to wait a short period of time for compensation is, from the consumer's perspective, is tolerable in my submission. So I wanted to take the court to a passage in Cruiseman about legality, because it's a relevant point I want to make later. Paragraph 46 in Cruiseman on page 145. The court says that its finding isn't called into question by the fact that the movement should be regarded as a wildcat strike, in the meaning of the German legislation. It wasn't officially initiated by a trade union. Making a distinction between strikes which, under applicable national law, are legal from those which are not, in order to determine whether they are extraordinary circumstances, would make the right to compensation dependent on the social legislation specific to each member state, thereby undermining the objectives, the harmonising objectives of the regulation. And so it's common ground that here the court is not making a distinction between strikes called by unions and strikes that are wildcat. The question was whether it mattered that the strike was unlawful, because wildcat strikes were unlawful in Germany. And the court, unsurprisingly, said it doesn't matter if the strike is legal or illegal under national law. We can't have the application of Article 5.3 depending on national law. And paragraph 50, if one asks whether those paragraphs 38 and 39 that I place so much weight on or relevant. We see them again in the operative part of the judgment. So this is the dispositive part of the judgment, and it goes from page 146 into 147. The court rules that Article 5.3 must be interpreted as meaning that the spontaneous absence of a significant part of the flight crew, such as that at issue in the disputes in the main proceedings, which stems from the surprise announcement by the operating air carrier of a restructuring of the undertaking, following a call echoed not by the staff representative of the company, but spontaneously by the workers themselves, who place themselves on sick leave, is not covered by the concept of extraordinary circumstances within the meaning of the provision. So, you have my point, my lords, that if the court in Cruiseman wanted to go as far as the CAA, the judge below, they would have said so, and on inherency. And on the controlling, I will show you the Caa Skeleton on this, because they make a criticism of the appellant's construction. So the Caa Skeleton is on tab 12 of the core bundle. And we go please to page 123. Seven 7.2.1, the CAA quotes the relevant passage in Cruiseman that deals with control. And you have my point that in Cruiseman, there the court refers to the fact both that so here, there's no doubt the court is dealing with the question of control. So when the court deals with control, what does it focus on? It focuses on the fact that the wildcat strike stems from a decision taken by the air carrier. So you have control over those things that you do and choose not to do. And despite the high rate of absenteeism as mentioned by the referring court, the wildcat strike ceased following an agreement that it concluded with the staff representatives. Now, the CAA goes on to submit that those are the two reasons for considering the strikes in that case to be within the control of the carrier. However, the paragraph does not say that a strike is within the control of the carrier only where those two features are present. Pausing there, that's not my submission. My submission is not that the air carrier has control only when those conditions are present, but I do rely on them to show what control means within the Valentine-Herman test.
I mean, is the point you make this, that the conduct that happened after the wildcat strikes, namely that it was very easily resolved, apparently, by the airline and the staff representatives, is simply relied on to show that actually the problem was caused by the airline making the announcement by surprise without prior consultation?
Yes.
And that's your point, isn't it? It's really the use of the events afterwards really cast light upon what caused the problem.
Absolutely.
Because, in other words, it's only if the airline had actually asked people first before, or just notified the units before making the announcement about restructuring, none of this would happen. None of this would have happened. That's the sort of flavour that you say we should get from this.
Indeed,
Right?
Indeed, because it goes to inherency and control. The court emphasised again and again that the cause was a surprise announcement of the restructuring. Why is surprise relevant?
Yes, but what I'm saying is that rather than ask what seems to be quite a difficult question about what do you get out of the fact that there was a quick settlement when you're addressing control, which is quite a difficult question conceptually, it seems to be in fact more directed at a sort of either the first question or some sort of composite question, in a sense, what caused. That's your argument, I think.
It is, my lord, yes, and forgive me if that wasn't clear. Control is a very broad word, and sometimes I speak of responsibility. But which is what was in
travaux, in fact.
Indeed, and that's closer to what my lord is describing to me, that really the fact that they went on strike straight away because of this surprise announcement suggests that it was caused by the airline, and the fact that it was resolved so fast again shows that the airline could undo what it had done, that which had caused the strike. And then we see this interesting passage in the Caa Skeleton at 7.2.2. Here the CAA appears to criticise what the Court of Justice did in Cruzman. The CAA says it's also doubtful whether the fact that the strike ceased following agreement between the parties is truly indicative of control, since it will always be the case that a strike can eventually be brought to an end by agreement. And in my submission, that demonstrates that the CAA is struggling to reconcile its interpretation with the judgment in Cruzman, because the court in Cruzman did regard the way in which the wildcat strike ceased as relevant to the question of control. It may be the court had in mind the point that Justice Snowden was making to me, which is that it goes more to responsibility and the cause of the event. But it's certainly material to what the Court of Justice had to address. The next authority, if I may move on, I'm conscious of time. I'm anxious to finish before lunch. I didn't think I would need to take more than half a day with the court, so I'll move on, if I may, to Powell's.
No, you make more submissions.
I'm grateful, but I appreciate I'm going over authorities that you've seen, so if I'm labouring a point or you've read it before, please move me on. But the next authority is, in chronological order, is Powell's. Forgive my pronunciation, it's behind tab 13, Powell's, another German wings case, behind tab 13 of the authorities bunch.
Yes.
This is the screw on the runway.
Yep.
And it's useful in my submission because, again, runways are, like staff, absolutely part and parcel of an aircraft's operations. Their use is indispensable and obviously recurring. But what the court here finds is that where the runway problem is external, we see a finding of extraordinary circumstances. And the reasoning of the court begins from paragraph 21 on page 152. To 23. So it starts off with the point that basically problems with tyres are normally inherent, and the case law says that even an unexpected malfunction of certain components constitutes in principle an unexpected event intrinsically linked to the operating system of the aircraft. And then at 22, air carriers are regularly faced with such malfunctions in the light of the specific conditions in which carriage by air takes place. And then 23, it's common ground that aircraft tyres are components which are on landing and takeoff subject to very great stress and therefore subject to a permanent risk of damage, justifying particularly strict regular safety checks. And then 24, importantly, however, where the malfunctioning in question is the sole result of the impact of a foreign object, which must be proven by the air carrier, such malfunctioning cannot be regarded as intrinsically linked to the operating system of that aircraft. That is inter alia true of damage to an aircraft caused by a collision with a bird, as is damage to a tyre caused by a foreign object.
If you took this and you go back to the point that was made in one of the early authorities, that there are actually sort of two components to the operation of an airline. One's the kit and the other is the people. I can understand if your people are stopped from getting to work, that's external. But if your people, for whatever reason, decide not to turn up to work, why isn't that the equivalent of an inherent, albeit unexpected, malfunction of part of the airline?
Because in that situation, well, the people, assuming they have behaved as unreasonably and in as disruptive a way as the passenger in the LE tap case that I'll come to, assuming they have done that, putting to one side my union point, Then the analogy is with the manufacturing defect. Because remember, the court has said, if there's a problem with the aircraft,
So you say the people have behaved unreasonably. I mean, the people, the airline, the staff just decide they don't agree, they want something different, they go on strike. You're saying that's inherently unreasonable?
I don't know. That's the question, and that's why the analogy is with, I discussed it earlier, with the disruptive passenger. If the strike arises from something which is much more straightforward and normal, like the regular pay negotiation that my lord put to me, then it may be very hard for an airline to say, in those circumstances, it's extraordinary circumstances. There has to be some analysis of the cause of the strike. Now, my lord, even where there's a problem with the kit, the Court of Justice has said that certain defects are, even though they're in the machine, which is absolutely indispensable for the airline, it's not their responsibility, and it is extraordinary circumstances. If it's a manufacturing defect, they couldn't have identified it, and they found out about it from the manufacturer. And that's the analogy I seek to draw.
You say it's the involvement of the union, you say, which makes this the equivalent of manufacturing defect. Is that right?
Is that, and even if I'm wrong about that, it's the extremely unreasonable behaviour of the union, which means that in substance it is akin to the manufacturer's defect, because there's no way the airline could be treated as having any responsibility over that situation at all. And that question, in fact, it may be answered in 9 times out of 10 against the airline, but the question has to be asked, and that's really the debate between us.
The way the court expresses itself in the Germanwings case is quite narrow, isn't it? 24, they say, malfunctioning is the sole result of the impact of a foreign object. It cannot be regarded as intrinsically linked to the operating system of that aircraft, not the airline's business or anything like that, which is the phrase that's been used in other contexts, but it's that aircraft, that particular aircraft. And that's their explanation of the bird strike in Pescara. And then they go on to say in 26 that the fact that the air carrier is not responsible for clearing a runway means that the screw on the runway is not within the airline's control.
Yes. The last point, my lord, just turns to what's the competence, what's the power, or
yes, quite. That's the point
case.
Made in the petrol on the runway case.
Indeed. The earlier point about the distinction of referring to the aircraft as opposed to the normal operations of the airline, it's not clear. I suppose the court is answering the question that was asked.
Yeah.
And traditionally doesn't like to go further. But in my submission, adopting the analysis of kit and staff, there's no doubt that one can have extraordinary circumstances in relation to staff also, in the same way one can have them with kit, even kit. In 26, yes, we've seen that because that deals with control as well as inherency. And the next authority is Moen's. This is the petrol case, and I'll deal with it briefly.
Yeah.
Behind tab 14. Paragraph 8, it's page 158. And we see at 18, paragraph 18, again, we focus on the origin. Court says, with regard to the question of whether the presence of petrol on the runway of an airport led to its closure falls within the concept of extraordinary circumstances, when the petrol in question does not originate from an aircraft of the carrier that operated the flight, to be noted logically, such a circumstance cannot be regarded as intrinsically linked to the operation of the aircraft. And at 19, such a circumstance cannot be regarded as inherent. And 20, it's beyond the effective control of the air carrier, given that the maintenance of the runways is in no way within its competence, an echo of what we've just seen. And again, I rely on this by analogy with the external factor, which is the union, and the fact that both formally, but also in substance, the airline has no control over the acts of the union, the position it takes. The final Civil Aviation Authority I wish to take you to is the one I've been mentioning as we've gone along, the LE and TAP case. That's in tab 16, page 174. This is the unruly passenger. And if you go please to page 182, the court deals with inherency first at paragraph 41. And so dealing with inherency, the court says the unruly behaviour of, so we've got a very disruptive passenger, and the court says the unruly behaviour of such gravity as to justify the pilot in command diverting the flight is not inherent in the normal exercise of the activity of the operating air carrier. Supposing they're plainly passengers, I mean, when Lord Justice Snowden said the essence is the staff and the kit, well, one could say passengers are also a fundamental component of the business. And ordinarily, the behaviour of a passenger would be inherent. Just logically, one would say that has to be as inherent in the business as the staff. And the behaviour by the passengers has to be part and parcel of how you operate.
I mean, it is a bit odd, isn't it, in the sense that you would have thought that airlines should have a responsibility to ensure that either drunken people don't get on people who are visibly drunk don't get on the plane, or alternatively, they don't serve them sufficient alcohol to make them drunk on flights.
And the last point, what I think we'll see in the judgment, but the basic point of surely airlines are responsible for passengers.
Well, to some extent, to make
Yes.
sure it's making sure unruly people who they can tell are unruly don't get on the plane. I mean, somebody who just is this what I don't know from the facts is whether this was somebody who simply came on behaving perfectly normally and then became unruly.
That's the question which the CJU directs back to the referring court. Because I think in order to answer, the question the referring court has to address is, was the airline in any way responsible? And that suggests that the Court of Justice itself didn't know or didn't have all the facts about how the thing actually happened. Because if the airline is in some way responsible, for example, by serving a slightly drunk person lots of alcohol, then it isn't extraordinary circumstances. But my basic point is, here we do draw a close analogy because passengers are as fundamental to the operation of the airline as staff. And the court says not any bad behaviour will do. It has to be extreme unruly behaviour. And it says at 42 on page 182, even though the carriage of passengers by air is the primary mission of the carrier and naturally exposes it to the duty to manage the behaviour of the passengers it carries, the fact remains that behaviour such as that in issue in the main proceedings does not constitute behaviour which can be expected of a passenger who is responsible not only for complying with all orders issued by the commander, but also for ensuring he doesn't himself jeopardise the proper performance of the contract of carriage between himself and the operating air carrier concerned. And when the court says not behaviour that can be expected, in my submission, that's not a foreseeability point, because it's foreseeable that some passengers will, from time to time, be just as unruly. The point that's being made by the court in my submission is that a passenger was behaving so unreasonably and inconsistently with the contract of the airline that it fell outside what would ordinarily be treated as inherent into something that was extraneous. And the CAA, in response to these passages, says, well, workers are free to strike, and no one could say a strike is illegal, unlike the conduct potentially of this passenger in LE. And we make 2 points in response. First, a striking employee also acts inconsistently with the employment contract. And there may be statutory protection against dismissal, but that's different. They are acting on their own behalf to protect their own interests. They're not acting as an employee or agent of the airline. And
Sorry, you're saying if an employee strikes, that's a breach of his contract of employment?
Well, it will depend on the terms of the contract, but it'll be inconsistent with this employment contract, with the basic purpose of the employment contract.
It often will be a breach of contract, won't it?
It often will be a breach of contract, although it depends. I mean, that maybe the person is striking because the airline has breached his contract. We don't know, but it will often be in breach of the contract. But he has statutory protection even in those circumstances from any dismissal. The second point, of course, is that it doesn't matter if the strike that we suffered was legal, but the Portuguese passenger acted illegally. The court in Kruzman has said distinctions of legality under national law cannot be determinative of whether something is extraordinary circumstances or not.
Yeah.
And the CA then says, well, this is different because the Court of Justice in LE was influenced by a concern not to penalise airlines that are taking safety measures. It's a safety issue here that doesn't arise in other cases. But in my submission, that's not what the court says. And in any event, all of these cases involve safety considerations. In all of these cases, the steps taken by the airline are motivated in whole or in part by safety considerations. And even a strike has safety consideration. For example, the airline cancels the flights when pilots strike, partly because it can't pull in pilots from or non-striking pilots because they've already flown their maximum numbers of hours. So the fact that the strike is effective to prevent the planes flying is also safety, involves safety considerations. Safety arises in all of these cases. And we come then to the question of control. In 43 of LE, we see, at the top of page 183, the Court of Justice says, such behaviour is not in principle under the control of the operating air carrier concerned, since first is the act of the passenger whose behaviour and reactions to the crew requests are not in principle foreseeable. Secondly, on board an aircraft, both the commander and the crew have only limited means of controlling such passengers. And then we skip down to 45. However, that's not the case if it's apparent, which is it is for the national court to ascertain, that the operating air carrier concerned appears to have contributed to the occurrence of the unruly behaviour of the passenger concerned, or if that carrier was in a position to anticipate such behaviour. That's my Lord's point, and to take appropriate measures at a time when it was able to do so without any significant consequence to the operation of the flight concerned. Again, that's factual query. In my submission, the airline in this case had a comparable level of influence over the unions as that airline had over the passenger. And it may be that in a particular case an airline will have no influence over a disruptive union. They're both external third parties over which the airline has very little control. And so we ask why, if an unreasonable passenger, a very unreasonable passenger, is not inherent and beyond the airline's control, why then, if the union is behaving extremely unreasonably and the airline has no control over it, why is that not also an extraordinary circumstance?
Are you saying that is it part of your case that Ryanair couldn't anticipate that it would be asked to change its system for deploying pilots?
That's the unchallenged evidence, that when the negotiations began, Ryanair had no idea that they were going to come forward with these 11 demands, which involved the whole business model being destroyed. And that's in the evidence, Mr. Hughes, which the CA doesn't contest. Now, I'm stopping there, my lords, on the EU authorities, because that's Brexit.
Yeah, well, I wanted to ask you a Brexit question, if I may.
You may.
If I have understood correctly, we are bound by pre-Brexit case law in CJEU, except in circumstances where the Supreme Court might depart from one of its own previous authorities.
Yes.
Well, let's assume that we're not going to depart from anything the CJEU has said. And let us assume for the time being that we don't look at post-Brexit CJEU authorities. Well, no, there is one potentially quite important one in the bundle, which no doubt, yes, you will have guessed we've looked at. But how do we now, as effectively a common law court, develop the law?
My Lord, Parliament has given you the steer, which is that, it's in the authorities bundle, if I may take you to it, behind tab tab 3, page 38.
30,
38,
38.
section 6,
36.
sub 2 of the European Union Withdrawal Act 2018.
Yeah.
And this sub 2 instructs the court that you may have regard to anything done on or after.
No, I follow that.
Yeah.
So leaving aside what the CJEU has done since then,
yes.
what do we do as a common law court? I mean, the analogy that I had in mind were, for instance, Australia or New Zealand inherited English law at a particular date,
Yes.
but their courts develop it.
Yes. And that's
Are we in that sort of position?
You are. And the reason why I took you to this, my lord, is that Parliament here is saying that in relation to post-Brexit CJU case law, even if it's relevant, even if it's actually relevant to the issues before you, you're not obliged to even have regard to it. You are free to develop the law as you see fit.
Right.
So to the extent that there's a concern that the law here may diverge from EU law, that's already happened. Because the CAA, for example, stated position before you is that, for example, a sympathy strike, a strike in sympathy for some workers in a different unit or a different company, that would not be, that would be extraordinary circumstances. That would not.
Well, that's what they say, but has the court decided that yet?
Yes, the European Court has said in a case also in your bundle, CS and Eurowings, that would fall within the responsibility of the airline, and that would
No,
not.
I'm following. So the CAA statement, is the CAA statement binding on anybody?
No, my lord, but it's the position. No,
Well, is it the position they take? Yes,
yeah,
sure.
but that demonstrates that divergence
Yeah.
is already taking place. The question is, what is the right approach for this court to take, putting to one side any concern which you should not have about divergence between the United Kingdom and the European Union? And it's our clear submission to you that you ought to give our interpretation of Article 5.3, which we say is not only consistent with the binding case law, but is also a sensible and proportionate solution, which is well capable of swift resolution by county court.
You accept, I think, that pre-Brexit there is no case, no decision of CJEU which covers this situation.
That's correct, my lord, yes.
So there is nothing, so to speak, directly binding on us.
Yes.
We are being asked to apply certain statements which the CJEU has made by analogy.
Yes.
And can I ask you this, that are we free, if we choose, to develop the law in a way which we consider serves the purposes of the regulation and is not inconsistent with anything the CJEU has said pre-Brexit?
Yes, you are free to do that.
Thank you.
In fact, again, Mr. Coates directs me to what Lord Justice Green said.
Yes, well, I don't think he goes into this question of developing the case law, does he?
No, but I just see.
I read with interest what he had to say about.
I'm reluctant to ignore a suggestion from Aaron Jr., so I turn to it because they're normally worth following up.
Yes.
Paragraph 83, page 209. Yeah, that's the point we've been discussing already.
83.
Paragraph 83.
Yeah.
The differences between the current state, as time moves on and the case law of the CJU evolves, then the differences between the current state of EU law and that which the court is to take account of may become more accentuated. At that stage, analysis might become more complex. So Lord Justice Green there is contemplating that.
Yeah, well, he deals with CJU case law at paragraph 65 to 70, but I don't think that he explains what a domestic court can now do.
No, he simply recognises, we infer from what he says, that differences may well become more accentuated as the common law takes over, without regard to the Court of Justice. And this is a classic example of why we urge the court to do that. We say that, and I'm not going to take you to air help or the other CS Eurowings case, because the judge below didn't rely on it, and the CA does not rely on it either. So I'm not sure what, if anything, they'll say about it. I'll deal with it in reply if I need to.
Fine.
This is a classic case where the court should, with confidence, follow its own view, and we say by adopting our interpretation of Article 5.3, you are faithful to the pre-Brexit jurisprudence of the court, but you'll be producing a proportionate solution which secures the objectives of the regulation without unreasonably prejudicing the airlines. That the balance that is thought to be struck in the regulation. And my final point then is to turn to the judgment itself, which you have in the court model, as you've seen.
Sorry, Mr. Kennedy, I was making a note. We're going to the judgment.
The judgment, yes, please.
Yeah.
And that's behind tab 6. And I'll deal with how the learned judge addresses inherency first. And you have that from paragraph 40. Paragraph 40 on inherency. And in part, sometimes the learned judge deals with inherency and control in the same passage. But hopefully we can distinguish between them. Paragraph 40 on page 57 says what follows in his judgment is it makes no difference who causes the walkout. It's difficult to see any material difference between this case and Cruiseman. In Cruiseman, it's clear the strike was caused by the employer announcing at short notice its corporate restructuring. Why should it make any difference if the unions make unreasonable demands? The union's position was endorsed by the employees. Why should it make a difference if the employees make demands at short notice? Why is that an extraordinary circumstance? It's all to do with the normal activities of the air carrier. And then at 43, the learned judge says, moving on to matters in the area of negotiation of terms and conditions, as a matter of principle, practicality and reality, negotiations between employer and employees and their representatives, whether unionised or not, are part of the normal activities of air carriers. He goes on to make the point that may lead to negotiations which involve outrageous or unreasonable or impossible positions, some knowingly unattainable, which ultimately result in resolution by compromise or concession. And then if I may pull out 47.
Curious, we've got 3 paragraphs 43 and no paragraph 44.
Yes, there were, yeah. Well, I'm sure that's council's fault for not. Did you get a draft? It's more.
47 we're going to.
47, yes. And then he says in more detail, by recognising the unions and negotiating with them, their involvement was or became an internal part of the carrier's activities, inherent in its normal activities. And again, the point that the positions were apparently approved by the employees. Now, as to the judge's first point, that any employee negotiation and strikes that follow are part of the normal activity of an airline, you have my submission that the CJU did not go that far in Cruiseman. They did not adopt such a broad general principle. And they didn't do so because prima facie strikes are extraordinary circumstances, and Cruiseman is a limited exception to that. And then, as to the point that workers and unions, if you recognise them, are part and parcel of an airline's operations, again, you have my point that passengers are equally fundamental to an airline's operation. But that doesn't prevent, as we saw in LE, an unruly passenger amounting to an external, non-inherent circumstance. And I made the point to Lord Justice Lewison that, again, runways are equally fundamental. But that doesn't prevent runway closures being non-inherent if the circumstances are appropriate, as in the Moens case. And again, I repeat the point that even in areas that are undoubtedly part of the aircraft's operation, such as manufacturing defects, even they can be external origin and amount to extraordinary circumstances, as we saw in Pescova, in Valentin Herman. So we say, and you've got the submission now many times that part of the operating system is affected here by something external. Part of the business is affected by the union, which is an external thing. And there's no analogy that can be drawn between the strikes and staff illness. Staff illness, we can see, is analogous to the wear and tear of an aircraft. But that's not a proper analogy with this case. And really the error that the learned judge made was he failed to recognise the significance of the uncontested evidence and his own finding that the strikes had their origin in the demands of an external and independent union. Now, you have my point that we maintain that unions are external. They have the support of the employees, sure, but they are populated in this case by employees of other airlines. They represent the employees in one sense, but they do have an external, independent view of their own.
I mean, just two things on that. I assume at this stage, well, I don't know, when did Ryanair employees join the unions? Was it post-recognition?
January 2018, post-recognition. Sorry, actually January 2018 would be pre-recognition.
It would be pre-recognition.
Yes.
So, the point I'm just wondering about is when it said, well, the union people came from other airlines, was it necessarily the case that they came to other airlines because at this stage came from other airlines because at this stage Ryanair employees were within the scope of the unions?
It doesn't, my lord, it's not my submission that there were no Ryanair employees in the union at the time of the strike. The point is that one cannot say there's no distinction between the block of Ryanair employee union members and the union itself. The union was supported by those employees, we assume, but the union is an independent force of its own, and it is representing Ryanair workers, but also the interests of employees of other airlines, which are direct competitors of Ryanair. And the union has its own independent view.
Which is my second point. One would think that a union has an obligation to act in the interests of the relevant members. We have to assume, do we, that this union is not acting in the interests of its relevant members?
Well, Ryanair's position is that the union wasn't acting in the interest of the members, but I can't push that point because we assume the employees were balloted, and we know actually from the evidence they were balloted.
Yes, I think.
So it's a law. So to that extent, the union was supported by the employees. Yeah. My point only needs to be this, which is that the judge erred in saying there was no distinction between the employees acting unilaterally without independently of the union. And the union involvement introduces a external factor, which is not exactly the same as the block of Ryanair employee union members. And by way of factual support for that, I point to the lack of any strike, subject to the point that I have to clarify with my lord, prior to 2018. The union plainly introduces something new, and it's clear to see what it is. It's clear in the evidence and uncontested. The union wanted to change Ryanair's whole business model. Yeah. No suggestion that demand came from the Ryanair employees.
But it's rather odd if it didn't. I mean, why would the union representatives be asking Ryanair employees to back these particular proposals if Ryanair employees didn't want those proposals?
Well, we have to assume that the employees supported what the union was doing. But in the evidence that if you have time to review it, there's no suggestion that the particular demand that the whole seniority determined rostering and location originated from any grievance with the employees. This is a classic situation where it happens where the union says, trust us to represent you, we'll fight your corner, and this is the tactic we will adopt. And perhaps that's what employees want the unions to do this. But this was very much driven by them, and you'll see it in the evidence. But all I need to say, even if I'm wrong about that, is that the union introduces an external factor which moves it into that extraneous area. And if the union behaves in an entirely unreasonable way, we know from the LE TAP case that is material to whether it's extraordinary circumstances or not. And the judge agreed with that, but failed to apply those findings to the facts of this case. and I'll make the point I made again, that the very object of a strike is to disrupt the normal commercial operations of an airline. Now, on control, we see the learned judge's findings in a number of places. Paragraph 28, he says, this is page 54, he says, the defendant's construction of control is too narrow. All that is meant by control is something which is part of the carrier's normal activities, whether or not it involves industrial or other relations, is to be treated as something that's within the carrier's control, because it's the activities of the carrier, and therefore within or part of its actual control. Pausing there, that robs control of any meaning. The judge is saying, if something's inherent, the air carrier has control over it.
Yeah.
And paragraph 39, on page 57, he's gone through the passages in Cruiseman, and he says that the point being made by the CJ in Cruiseman in relation to control is not the literal narrow sense, but the wider sense of something which is within the ambit of the normal activities of the business.
Where are you, Mr. Kennelly?
Paragraph 53.
53.
Sorry, I'm so sorry, 39. Paragraph 39.
39, right, yeah.
On page 57.
Yeah.
I'm looking ahead. So, the learned judge here has read Cruiseman, and he's saying that the point about control in Cruiseman isn't the literal narrow sense, but the wider sense of something which is within the ambit of the normal activities of the business. So it doesn't follow because one side walks out and negotiations break down that the strike is beyond air carrier's control. Once it's part of the normal activities of the business, then it's within the control of the airline. And finally, and that's the findings which the learned judge makes about control go on at 51, my lords. On page 59. So he says, again looking at control, at the point in time when the union employees went on strike, the defendant was not in a position to satisfy and avert the strikes and did not have sufficient time to give notice to passengers within the time frame. But that does not mean that they were not in control or that it was out with normal activities. It just means there was a hitch in the negotiations and the employees were adopting the recommendations of their union. In 51, why is this different from Cruiseman? It's impossible during dynamic negotiations to lay fault on either side. The minutes articulated, it reveals the heavily fact-specific nature of the inquiry. Each side, no doubt, realizes others having extreme or unreasonable views, and there's no need for a granular approach. Now, to be clear, my lords, this isn't a finding specific to Ryanair. It doesn't matter, the judge is saying, if the union or employees behave unreasonably or extremely unreasonably. Even if the airline is faced with a choice between acceding to the demands and insolvency, or even if the demands themselves, if acceded to, would lead to insolvency. It doesn't matter. This is part of negotiations which can be extreme or unreasonable, and they will not be extraordinary circumstances. Once the staff, according to the judge, once the staff are complaining about their own employer, Article 5.3 will never apply. And although the learned judge is saying should be no granular fact-facting, he's really disavowing any any fact-finding apart from whether they're complaining about their own employer or not. And we know that some fact-finding is appropriate from the Court of Justice's case law and even from what the Court of Appeal said in Lipton about strikes cases. And the judge, we say, erred in refusing to ask if the union's demands would in any way have been met in the time frame. And that high-level question does inform whether the union or employees were being unreasonably disruptive. And it's a question which is addressed by the Court of Justice. And I've accepted in questioning from the Court that this is not a bright line distinction.
This is what?
It's not a bright line distinction,
Yeah,
not a hard-edged test. If, because we know from the LE TAP case, that the airline's own contribution to the situation is relevant. So if in a particular industrial negotiation the airline behaves unreasonably, or if the discussion takes place as part of a regular pay negotiation, as Lord Justice Snowden described to me, then we're in very different territory. That involves considering whether the airline contributed to the situation. But the uncontested evidence here is that the airline was confronted by a unilateral demand from the union and could not possibly have averted the strikes. Now, the very final point, my lords, and you saw it in the judgment, and this goes to the interpretation of the case law of the court, is the extent to which it is proportionate, whether the CAA's interpretation and that of the judge below is proportionate and complies with Article 28 of the Charter, which seeks to strike a balance in collective bargaining negotiations between workers and their employers. And the short point here is the CAA says in their skeleton that imposing liability on airlines to compensate passengers in the event of a strike will not necessarily confer a significant advantage on the unions. And the short answer to that is it's just completely unreal. The CAA says in its skeleton, I shan't turn it up, paragraph 8.4, that the approach taken by the judge below means that the airline's rights, the balance in collective bargaining, is unaffected. That is a completely unreal submission, because one can easily imagine in any industrial negotiation between unions and airlines, the union can make any unreasonable demands it likes, but it can say, if we strike, you will be liable not only for all of the commercial consequences that follow, which is perfectly normal and acceptable in union strike negotiations, but in addition, you will be rendered liable to pay passenger compensation in these sums as well if we strike. And for low-cost airlines, those compensation figures will often be higher than the price of the ticket. It's a major commercial weapon, a negotiating tool. And all we're saying is the judge erred, failing to take that into account. And the CAA is wrong.
You are stuck with that anyway. We can see from the CJEU more recent jurisprudence that if this dispute happened now across the European Union, you would be stuck with paying compensation to all passengers except those departing from the United Kingdom.
Indeed, my lord. But the fact
I suppose it might mean that you cancelled flights from the United Kingdom rather than flights from elsewhere in the European Union. But
well, that's a classic example. The Court of Justice has gone down the wrong road there. The idea that this negotiating tool in the hands of the unions makes no difference is obviously wrong. And all we ask is that the court takes it into account and recognises that it does have an impact on the balance that is sought to be struck between them and the proportionality of the interpretation of Article 5.3. The CAA says it makes no difference.
Suppose there is a flight from Stansted to Munich, say,
yes,
and then a return flight, and they are both cancelled. Does that mean that the passenger who would have got on at Stansted may not get compensation, but the passenger who would have got on at Munich would?
I fear that may be the case. I'll just quickly check that. It's UK departing flights. So the liability arises.
Yeah, but the passenger who would have got on in Munich
yes,
would have an EU remedy against Ryanair in Ireland, presumably.
Yes.
So
yes.
that passenger would get compensation, but the passenger who would have departed from Stansted would not.
Yes.
On your
yes,
case.
Indeed. There would be a divergence there.
I mean, the airline then would be very wise to make sure it cancelled the Stansted flight and not the return flight.
My lord, Ryanair is operating a business which seeks to make itself attractive to passengers, and in order for this to work, it has to behave with that paramount objective in mind. I'm not going to accept without proper instructions whether that's even an incentive that would arise in those circumstances.
Yeah.
And the fact that the EU has gone down a road which we say is manifestly inconsistent with the regulation shouldn't have an impact on the construction which my lords adopt. It really shouldn't, because then where would we be? The whole point of this is that this is an opportunity to say to this court, please don't do that, and be faithful to the pre-Brexit case law. I'll just quickly check if there's anything else before. Yes, so I think that the answer to my Lord Newey's question is that those earlier strikes had happened when people were joining the unions, and the unions were already in view. It was a precursor to the strikes that followed. And it was in relation to union demands, which they were making even though they hadn't been recognised. The easier solution may be, if my lords have time, is to actually read the whole of the Hughes statement. It's not very long, and it will answer that question.
Just before you sit down, Mr. Kennedy, can I just ask you a couple of procedural questions?
Indeed, yes.
The hearing before the judge was, so to speak, a final hearing of the Part A claim, is that right? It wasn't a hearing on motion or anything like that? No. So it was, for practical purposes, the trial?
Yes, it was.
If we are with you on the law, do you say that we should find the facts? Because the judge said, well, we don't need to bother with the facts. It's just knocked out because it's a strike. So do you say that this court should find the facts, or that we should remit it to the judge at first instance to find the facts?
My lords, you should find the facts.
We should find
and the law. You are as well placed as the judge below. The hearing has lasted for just as long, and you've got the very same materials before you, which are not voluminous.
Yeah.
And in the interest of procedural economy, we would urge you to do both.
Right. Thank you.
Can I just get the facts sort of straight in terms of chronology? The judge at paragraphs 3 and 4 simply records, I think, that the strikes followed the submission in May 2018 of the 11 demands, as you've described them. And he simply says that if Ryanair had accepted all the demands of the union, it would have impinged upon the viability of the business.
Yes.
I mean, the way it was put in Mr. Hughes's witness statement is, as I understand it, you took us to some paragraphs of it. The demands at you see at paragraphs 46 to 49, the demands were said at paragraph 47 to be new in the sense that they would involve large-scale and fundamental changes. I'm not sure I quite follow the syntax there. You answered my question to say that they'd not previously been intimated. There it says they're new in the sense that they'd involve large-scale changes. I'm not sure that's quite the same point. But in any event, what actually then happened, as I understand it, is there's a lengthy period of either engagement or non-engagement, depending on your point of view, between the unions and Ryanair, correct? And then the strikes take place sometime later in 2018. So it's delivery of, it's not like the case in Cruiseman, where it was announcement, immediate walkout or whatever. This is delivery of 11 demands, negotiations or lack of negotiations, lack of engagement, depending on your point of view, and then strikes later in the year, later in the summer, I think. Is that right? That's the chronology.
Yes, there's a chronology in the bundle, my lord, in the core bundle.
I mean,
and
where
you can see that the gap was months rather than days.
Yeah.
More as anticipated, exactly.
Yeah. Well, but as I understand it, your core submission is actually encapsulated in paragraph 65 at page 83.
Yes. Yes, indeed.
But it's yeah, and that is this right? You're saying that evidence wasn't subject to any challenge.
Yes, the CA's position was this is all irrelevant. So this evidence is not challenged.
Okay. And are there any other paragraphs that are relevant, or are you invited us to read the whole thing?
I'm inviting you to read all of Hughes, if you're willing to.
Right.
I've taken you to the paragraphs that I base reliance upon.
Yeah.
But in the circumstances,
Yeah.
I'd be grateful if you could read the statement.
Okay. Thank you.
Yes, thank you very much, Mr. Kennedy. Well, I think, Mr. Hahn, it's probably best if we start at 2 o'clock. Just as a matter of interest, how long do you think you're going to be?
Well, Lord, I would think about an hour. The law's been gone through
Yes.
extensively. I was proposing to deal with specific points that have arisen, and obviously not to grind through my skeleton argument, which I know your lordships have read already.
Yes.
So about an hour, I should think.
All right, fine. 2 o'clock.
What rise?